Welcome to Lecture 4, which covers Chapter 3, Regulatory Responses to Dark Patterns and Deceptive Design, in my book, Dark Patterns, Deceptive Design in the Law, AI's Hidden Influence on Our Digital Experience. The chapter asks a practical question. What have regulators actually done? It introduces the idea of a digital design acquis, a developing body of rules, guidance, and enforcement activity that recognizes manipulative design as a legal problem. The chapter opens with a transatlantic snapshot. The Federal Trade Commission increased scrutiny of deceptive design. California addressed dark patterns under privacy policy. The UK Information Commissioner's Office and Competition and Markets Authority issued joint expectations. In Europe, the DSA, DMA, EDPB guidance, and UCPD guidance all move the issue into mainstream regulation. The result is not a single code, but a patchwork of instruments that together regulate parts of digital design. The chapter then focuses on cookie notices. Cookie rules began as an attempt to create transparency and user control. In practice, many interfaces used legal duties as a design opportunity. Consent banners became systems for nudging acceptance through button prominence, confusing language, buried rejection options, and pre-selected settings. The law required consent, and the interface industry learned how to obtain it with minimal user resistance. Consent management platforms illustrate the problem. They were supposed to help organizations comply with the GDPR and e-privacy rules. Yet many default notices embedded dark patterns. The chapter explains how these practices conflict with requirements for freely given, specific, informed, and unambiguous consent. A user cannot meaningfully exercise data protection rights when the interface steers them away from privacy protective choices. The chapter discusses enforcement by CNIL and other European data protection authorities. Sanctions against major platforms illustrate recurring themes: insufficient information, lack of symmetry between accepting and refusing cookies, continued tracking after refusal, and consent frameworks that fail to provide specific and transparent choices. These cases demonstrate that data protection law can address visible consent manipulation, especially where the design makes acceptance materially easier than refusal. The Consumer Law section examines the Unfair Commercial Practices Directive in the EU and Section 5 of the FTC Act in the United States. Both regimes can address misleading or unfair practices. The UCPD focuses on material distortion of economic behavior, while the FTC Act focuses on unfair or deceptive acts or practices. These are both powerful tools, but digital design creates evidential difficulty. Manipulation may be subtle, context-dependent, and spread across a user journey rather than confined to a single statement. Chapter 3 also connects deceptive design to competition. Dark patterns can lock users into services, inflate retention metrics, increase switching costs, and disadvantage firms that compete through clearer design. An obstructive cancellation process does not only harm the individual subscriber, it can distort market dynamics by making poor products appear more successful and by punishing competitors that do not manipulate users. The enforcement difficulty is not merely doctrinal. Regulators face limited resources, cross-border complexity, inconsistent national capacity, and rapidly evolving practices. Some dark patterns can be captured by screenshots. Others require behavioral evidence, technical expertise, access to internal systems, and an understanding of platform incentives. The chapter therefore presents enforcement as both a legal and institutional problem. A central lesson is the need for coordination. Data protection authorities see data subjects. Consumer authorities see consumers. Competition authorities see market structures. Manipulative design often involves all three. The chapter therefore supports regulatory collaboration, shared evidence, common design expertise, and a broader understanding of how digital environments steer behavior. Chapter 3 shows that the law has begun to respond, but the response remains fragmented. Existing enforcement can address many visible practices, but it struggles with architectural and AI-driven manipulation. The next lecture turns to Chapter 4, which examines the newer EU legislative instruments that attempt to regulate digital design more directly.